Director penalty notices were introduced specifically designed to incentivize directors to lodge their tax returns on time. And this is really the greatest defense that you can have against the personal liabilities or damages associated with director penalty notices. If you've got your tax returns lodged on time, you get a period of 21 days from the issuance of a director penalty notice to appoint an external administrator and have the penalty remitted, so that is not become personally liable. Hi everyone, Liam Bailey here from O'Brien Palmer. We've had some fantastic feedback in relation to our recent videos. The most regular feedback that I've received has been asking for a topic specifically about director penalty notices. In the link below, you'll find a much more detailed fact sheet about all the questions that you could possibly have about director penalty notices. But in brief summary, I thought today we'd outline what director penalty notices are and how they can impact upon you personally. A director penalty notice is from the Australian Taxation Office and makes a director personally liable for the tax debts of the company under certain circumstances. The ATO issues director penalty notices when the company has failed, neglected or refused to pay and/or report tax obligations or has significant unpaid debts. Once given, a director penalty notice will either make the director immediately personally liable, which is known as a lockdown notice, or give you 21 days to satisfy the requirements of the notice or otherwise risk becoming personally liable. To satisfy the requirements and avoid personal liability, the company has a number of options. Those options include 1. Pay the tax debt, 2. Put the company into some form of external administration, or 3. Prove one of the defences that are available to the director penalty notice. So what is a 21-day director penalty notice? A 21-day DPN, or a traditional DPN, is a notice requiring the company to do one of those things within 21 days or face being made personally liable for the company's tax debts. A traditional or 21-day director penalty notice is given by the ATO when a company's tax liabilities are not paid but have been reported to the ATO within 3 months of the relevant due dates. Under the provisions of the Taxation Administration Act, a traditional director penalty notice gives the director of the company 21 days to do one of the following: for the company to comply with its obligations and pay the debt, to appoint an administrator to the company, to appoint a liquidator to the company, or to appoint a small business restructuring practitioner to the company. You can find further information about all of these types of appointment further down this page. What this basically means is that the company has to enter into arrangements to pay the debt in full or otherwise appoint somebody to formally compromise the debts of the company within 21 days. Otherwise, you're effectively issued a personal guarantee for that debt and you are personally liable for the debts that the company's incurred. So when does that 21-day period commence? The clock starts ticking 21 days from the date that the director penalty notice is issued by the ATO. That is, that it posts it or leaves it with you. Whilst it is possible to challenge the issuance of a director penalty notice, the legislation and the case law makes it clear that the onus is upon you as the director to be able to challenge that, and it is incredibly difficult because the ATO is issuing thousands of DPNs every month. They've become very good at making sure that they get this right. So I wouldn't rely upon being able to challenge a DPN, and I think you need to consider that a DPN once received has been validly issued and to consider your options that it provides for you. What is a lockdown director penalty notice? A lockdown DPN is given when the company's tax liabilities have not been paid and have not been reported to the ATO within 3 months of the due date. When lockdown DPNs are issued, the only way to avoid personal liability is for the company to pay that debt in full. The reason for this is to ensure that directors cannot avoid the liability for an aged taxation debt by placing the company into administration or liquidation. Who can be issued with a director penalty notice? Anyone that's a director of a company at the time that the company incurred the relevant debts can receive a director penalty notices. This includes if you have already retired as a director of the company, but were a director at the time that the company didn't pay its tax debts, or at the time that it failed to report its tax debts to the ATO. New directors must wait 30 days after becoming a director before they can be issued with a penalty notice if they became a director after the due date. This is to give directors the ability to inspect the companies they become appointed to and make appropriate decisions about dealing with any liabilities they identify. The ATO have basically stated that any taxpayer who is not working with them to resolve their tax liabilities or is not compliant with their obligations is at risk of receiving director penalty notices. The ATO has stated in its stronger action policy that it is targeting companies that are unwilling to work with the ATO, repeatedly default on agreed payment plans, who don't have the capacity to pay and don't take steps to resolve their situation and are trading effectively whilst insolvent, who may have been subject to audit and have detected deliberate avoidance in dealing with the ATO, or where there is a risk of the company engaging in Phoenix activities. However, we have seen a dramatic increase in the issuance of director penalty notices in recent times at the discretion of the ATO. What defences are available to director penalty notices? To put it succinctly, they're not easy to be able to claim. The two defences for personal liability from a director penalty notice include illness and reasonable steps. In the matter of illness, if you can prove that you were too ill to take part in the management of a company at a time that you were its director, you can mount a defence to the liability under a director penalty notice. However, this is not as simple as saying that you were ill and unable to. You must be able to prove that your illness was of such a serious nature that you could not discharge your duties, and the burden of proof rests with you as the director. The issue of reasonable steps is even more difficult to prove. The reasonable steps defence requires that you took all steps to prevent the company from incurring the debts, or to take all reasonable steps for the company to comply with its obligations to report to the tax office, and were unable to do so by legal issues, such as being locked out from the ATO's portals, being unable to issue directions to accountants, and being unable to take any of the necessary steps to put a company into a form of external administration, which is necessary if you're unable to discharge your duties. These are not easy defences to uphold and should probably be the subject of a discussion with an insolvency lawyer. What are the consequences for non-compliance with a director penalty notice? The consequences for non-compliance with a director penalty notice include that the director becomes personally liable to pay for the tax debt. If that doesn't occur, the ATO can commence legal actions against the director of the company personally, and that can be pushed through to the issuance of bankruptcy notice or the commencement of a bankruptcy of the director personally. The other outcomes include the issuance of garnishee notices to the director to take possession of assets or money held in the director's bank accounts. All of these can have serious consequences for a director and the director's personal assets. The liabilities are quite onerous for a director, which is why it's important to contact a tax debt lawyer or your accountant or an insolvency practitioner, such as myself, as soon as possible after receiving director penalty notices. So what are the takeaways from today's video? Director penalty notices were introduced specifically designed to incentivize directors to lodge their tax returns on time. And this is really the greatest defense that you can have against the personal liabilities or damages associated with director penalty notices. If you've got your tax returns lodged on time, you get a period of 21 days from the issuance of a director penalty notice to appoint an external administrator and have the penalty remitted, so that is not become personally liable. So the best defense that you've got is to lodge your tax returns on time. And it's really important to know that this includes, if you've been unable to pay your superannuation on time, make sure you lodge a superannuation guarantee charge statement within 1 month of the due date, and that your tax returns are all lodged within 3 months of the due date. The other major takeaway is that on the issuance of a director penalty notice, don't put your head in the sand. Talk to your accountant, a qualified lawyer, or an insolvency practitioner like myself, so we can explore the options available to you to not only turn around and save your business, but to protect you from the personal liabilities associated with director penalty notices. There are a lot of options available, but the more time goes by, the less those options are feasible. So don't put your head in the sand and speak to someone today. Or is in the suspicion of, or is under... I'm gonna start this all again.
Alright, no worries.
Alright, next page. It's hard because it's so...
Yeah.
It's such a general... Yeah, I think that's...
That's enough?
Yeah.
That's cool.